Please be seated. The court is now back in session. Before hand over the floor to the co-prosecutors to make his observation in relation to the request to present a document to the witness, the chamber wishes to make a notice that Judge Koropkin has an health issue this afternoon, so he will not be present in the courtroom during this afternoon session. Now, the chamber gives the floor to the international deputy co-prosecutors to make observation on the document requested to present to the witness this morning.
Thank you, Mr. President. We don't object to the specific use of this document under these circumstances, but I want to make it very clear why that is. It's because this is a one-page document, because counsel explained in very clear terms what he intends to do with the document, and we've had a 2-hour break to review it. If any of those things were different, we would object. If it were a longer document, if counsel had not explained how he intends to use it, or if we had had less time to review. And the reason we would object is because a lack of notice does cause us real prejudice. When a document is not noticed, by the time we've opened it and taken a look at it, counsel may be on their second or third question, and we still wouldn't have had a chance to figure out how it relates to the witness's testimony and to put it in context. And I should specifically note in that regard that we don't accept the idea that this document is so well known that everyone in the courtroom will immediately be familiar with it. In a case file with as many documents as this one, no one can be expected to be familiar with the nuance of every page of every document, and that's one of the reasons that we have these notice rules. This in particular is a Revolutionary Flag magazine. There are quite a number of those on the case file, and they're fairly lengthy documents. So we understand that a degree of flexibility is required in the implementation of procedural rules, and we also realize that at some point we may be asking Your Honors for flexibility. But nevertheless, the rules need to remain the rules, and the exceptions need to remain the exceptions. So while in this particular case we don't object, we don't wish this to be understood as agreeing to any derogation of the basic rules that Your Honors have set out for noticing documents.
If I may react, Mr. President. It's an interesting answer, especially in the light of the fact that the international co-prosecutor himself last week, when examining the expert, came with documents which were not on the interface. And of course we didn't object to them. But I suppose the question touches on a larger issue, and that is, I understand that it is not the purpose of examination to surprise parties or to surprise the trial chamber. However, things come sometimes up during the examination in chief that weren't anticipated in preparing the witness. So I think we should not stick to a very difficult rule, which as a rule is understandable as such. But if we stick to the fact that something has to be on the interface and we have no flexibility as to putting documents in front of a witness, which in theory should all be known to the parties, then I think we're maneuvering into an area which we really, or in a sphere where we really do not want to come. So I think as a general rule, and maybe you should make a general finding on this or general ruling on this, if it is a document well known to all the parties, well discussed at length sometimes in 2-1, then of course parties should avoid the element of surprise, and we should all be able to, if it's not on the interface, to find it and to look for it, but we should still be able to use it. So I think maybe at this point in time it would be good if you trial chamber make a sort of general ruling as to what should be done in respect of this.
Your Honor, I apologize for rising again. There's just one more thing that I'd meant to say that Mr. Coppa reminded me of. As I understand it, his intended use of this document is to make the argument that the behavior of cadres on the ground did not match what he would say was a higher standard set out in Revolutionary Flag magazine. That, in our submission, is not an issue that arose during the evidence of this witness. It was foreseeable that issue, it was foreseeable before the testimony of this witness that issue is one that he might like to have explored.
President, what about lead co-lawyers? Do you have any things to address the courts? Have you read the document? And is your position is the same concerning the matter of putting documents into the interface?
Thank you, Mr. President. I will stand by what I said before the lunch break, and my position is similar to my colleague's position, Victor Coppe. I think there should be a rule, a principled rule, with regard to this issue. We should notify the day before the documents that we want to use during the examination. It's a simple rule. It's based on the principle of adversarial debating. It is enshrined in the internal rules. The parties have the duty to notify to the other parties the documents that they're going to use when examining witnesses. So I think it's hard to transgress this general principle. Of course, everything is subject to interpretation. I can understand that there may be an issue in exceptional circumstances and that it might be necessary to call upon a document that was not placed on the interface. So in itself, that's not a problem for me. But however, the rule should be the same for everyone, as I said before the lunch break. And we should, of course, be informed that there are exceptional situations. So we would like that the principles of adversarial debates be confirmed and that we be sure that documents be notified the day before, but on an exceptional basis during the hearing, we do not object to the fact that documents be presented if the other parties have the possibility of reading these documents or even to ask questions with relation to these documents. So, as soon as a new document is presented, the parties should be in a position to put new questions with regard to the usage of this document. So I agree with my colleague. So I think that the Chamber should rule on the basis of principle, and we should stick to this principle for the remainder of the hearings.
President, concerning document E3/746 after your perusal, after your reading. So what is your position on these documents?
I would have liked the Chamber to come up with a decision on principle before I say what I think with regard to the use of this document. If the Chamber thinks that this document should be used on an exceptional basis, that is not a problem for me.
Mr. President, sorry to reply. Just to be clear, the purpose of my questioning was not necessarily to put the document before the witness. What was my concern is to be able to use those very specific contemporaneous words and those revolutionary words, which, as I understand, are hardly used in Khmer anymore. So it's not that he has to recognize his document, but because he cannot. It's just about those words that you can see, which are not typical Khmer anymore. That's all.
President, Judge Fan, you have the floor.
Just to avoid further debate, do I understand the party submissions correctly? They don't object today to the use of this document for the reasons given. However, everybody would appreciate a directive by the Chamber on how we will go about the use of the interface in a more general manner. Do I understand that correctly? I look at all the parties and see heads nodding, because then we can go ahead.
Yes, with the difference, of course, that we are hardly ever examining in chief, and we're always reacting. So things come up during examination, and then we are in a different position.
And we will give thought to that when we develop the general directive. But are we okay with this? So we can go ahead. There is agreement by all the parties that this document can now be used by the Defense Council in this manner, on an exceptional basis and with the understanding that there will be general guidelines forthcoming.
That's correct, Your Honor, yes.
Yeah, okay.
Oui.
Indeed.
Thank you, Judge Vance. Mr. Witness, we had a long discussion about things that really do not concern you. Before the break, you might remember we were speaking about your unit chief, or very briefly about your unit chief and your group chief. And I want to ask you if you'll be able to describe, if you remember well, the attitude and the way of operating of the unit chief and the group chief. How did they interact with you? How did they interact with the other members of your unit? What kind of person was this unit chief? Now, I would like to use or to give you a few words and ask you if these words possibly describe the behavior of your unit chief and group chief. So, the first word I would like to use in order to ask you if that word describes the attitude and behavior of your unit chief would be authoritarian.
Answer concerning the word authoritarian. Actually, the chief ordered us to do labors every day.
In his behavior, was he, another word I would like to use, behaving like a Mandarin?
Answer. The position of the unit committee, they absolutely used the workers to meet the quotas of ANCA.
Would you use the word militaristic to describe the attitude of your unit chief or your group chief?
Answer. Yes, I can describe him as a materialism.
I heard something different back in the translation. I used the word militaristic. But I heard something.
Correction from the interpreters, I could describe him as materialistic.
Well, I said militaristic, not
Oh, sorry, militaristic. Militaristic.
I did give the interpreters the actual passage from the revolutionary flag, so they have it in front of them. Mr. Witness, would you describe your group chief or your unit chief as single-minded?
Answer. I could not describe him as he is single-minded.
I think I have one more left, or two more left. Would you describe either of them as bureaucratic or liberal?
Answer. I could not say they are, or he is bureaucratic or liberal.
Okay. I've given you some words in order to be able to understand how you would describe the behavior of your unit chief and group chief. Now, in a more general sense, could you, using your own words, describe his behavior toward you and toward the group or the unit?
Answer. I cannot say anything about this.
The reason I'm asking all this is because before the lunch break, you were telling that you were fearful of him when you would complain. People would be fearful of him because if a spoon would break, he would threaten people to send them away. So I'm trying to understand how things went in those years, what the interaction was between you and your unit members and the unit chief. So again, and this is my last question on the subject, please describe the attitude or stance, if you will, of this person.
When there was an issue, for example, of a broken spoon, nobody dared to go and have any discussion with the unit chief.
And this is exactly my question, or exactly the problem that I want to discover. Why is it exactly that you were fearful of him? What made you fearful of him?
We were fearful of him because of what we saw, that is the disappearances of people from the group and from the unit, and of course we presume those people who disappeared died.
But before the lunch break, we also established that disappearance is going away from the cooperative or the unit and not coming back, and not necessarily anything harmful to the person. Do you understand what I mean, Mr. Witness?
No, I don't.
Let me try it another way. I understand fear of something to happen is a personal thing, but I'm trying to find out whether you had or your group members had real reasons to be fearful of your unit chief or your group chief. So I'm trying to figure out exactly what he said, how he behaved toward you, etc. So would you be able to shed some more light about how he interacted with you and what made you fearful?
I was fearful of my unit chief was that those people whom I worked with disappeared and never returned, and that made me very fearful of him.
Okay, thank you, Mr. Witness. I'll have one last small subject, and that's the following. That's the situation of the food and the communal eating. Yesterday we had a witness testifying coming from another commune, and he told us that on a regular basis people were also eating fish with rice and soup, and sometimes beef, sometimes vegetables. Was that the same in your cooperative, your commune?
It was slightly different. At my cooperative, we had our own vegetable for our own unit, including the local vegetables, cucumber, pumpkin, etc. But we seldom had pork or beef. It's very, very rare to have this meat.
And how about fish? Did you have in your commune a fishing unit that would go out trying to catch fresh fish?
In my cooperative, we did have a fisherman unit, but there was no big pond or river in my area. We only have some small ponds, and the group of fishermen would go and find fish for us. And let me give you an example. As for the fresh fish we had, for a bowl of soup, we would have 1 or 2 pieces of fresh fish.
Okay, thank you very much, Mr. Witness. Mr. President, this ends my questioning. I would like to take the opportunity, however, to correct myself. Earlier this morning I said something about what is a record of hectares rice per ton. I used 16. It is in fact 14.8. I apologize. It's a Chinese record, by the way.
Oui, Monsieur le Président.
Yes, Mr. President, I wish to inform you that the Kyo Sampan team has no questions for this witness.
President. Mr. Southien, the Chamber is grateful for your testimony for today. And the hearing of your testimony has come to a conclusion, and you may be excused from the court and return to your residence or wherever place you wish to go to. And the court officer, please make an arrangement for the transportation of this witness to his residence or wherever he wishes to go to, and that is to do it in collaboration with the visual. And we have an issue to deal with, that is there has been a request of a protective measure to the trial chamber for the next witness. For that reason, we will take a 20-minute break and resume at 2:30 in order to deliberate and decide on the request for protective measure for the upcoming witnesses. The court is now in recess.
សូមជើងក្រោកឈរ